May it please the court, my name is Seth Seagraves. I represent the appellant, Saeed Laghrab, and at this time I'd like to reserve 4 minutes for rebuttal time.
All right.
This honorable court should apply the standard from Artist Whitehead versus State and find that Mr. Laghrab was diligent in asserting his claims and that he faced extraordinary circumstances that stood in the way of timely filing those claims. In doing so, we're asking the court not to vacate his convictions immediately, but to remand for a sentencing hearing on the merits of his petition and find that due process tolling is appropriate in this case. When we ask for the Whitehead standard to be applied, it departs from previous cases that this court has ruled on, at least 3 cases since Artist Whitehead, that considered the same issue and applied a test from Sands versus State, which was the later arising test. We think it's appropriate to use the Whitehead standard instead of the later arising standard. One, because the state has kind of conceded that in their brief. Both parties agree that the appropriate standard for due process tolling when the delay is kind of blamed on attorney misconduct is whether or not the appellant exercised due diligence in asserting his claims and whether or not extreme circumstance prevented those claims.
So, Mr. Seagraves, are you, and good morning to you, are you aware of the Civils versus State case that came out in December of 2021?
I'm not familiar, Judge. I'm sorry.
So, no, that's okay. As I understand, the basic part of your argument is that due process tolling should apply because the petitioner was ignorant that he had a claim, not ignorant, didn't know that he had a claim, and that, too, he received bad advice by counsel with respect to that. And I think Civil stands for the proposition, maybe a different proposition. So I think Civils quotes this, that a petitioner's lack of knowledge regarding potential post-conviction allegations, even when alleged to stem from an attorney's negligent failure to render advice to the petitioner, does not toll the running of the statute of limitations. So I don't know what that means in terms of this case, but that seems to suggest that you're arguing that authority is completely contrary to the argument you're making. And I'm wondering how you would distinguish the authority.
I would distinguish it basically, it becomes an issue of late discovery versus the diligence. And the problem is that
well, I think Civil says that it's not a discovery issue, that even your ignorance that you have a claim does not give rise to due process tolling.
I think the trouble that Civil gets us into when we consider that is that it cuts completely against the holding in Padilla. Because if a person can't know, they can't be diligent. Diligence would require knowledge. And so squaring that against the Whitehead standard, that they have to be diligent and that extraordinary circumstances could stand in their way, I think not being able to know, especially when you consider it in a Padilla context, because the whole point of Padilla was that the Supreme Court was considering and concerned with protecting a vulnerable class. They go at length in the Padilla opinion to say that this specific group of people requires more advice and more protection than the average defendant. And it is extraordinary. It's completely different. Say, like, for instance, I'm a United States citizen. If I plead guilty today and my attorney knows that I'm a United States citizen, they don't have a duty under Padilla. And that's because I'm not part of that vulnerable or protected class. And so the problem with saying, oh, well, late discovery is not an issue is, well, it's the entire point of Padilla.
So you're asking then for a discovery rule, that we import a discovery rule into the context of due process tolling of a post-conviction statute of limitations,
I think
whereby the statute of limitations cannot begin to run until the petitioner is aware that he or she has a claim for post-conviction relief?
I think only in this limited context.
Only in the context of the Padilla warning?
Yes. And the reason is because how can you assert a Padilla claim if you don't know? How can you be diligent if you don't know?
Well, doesn't that apply then to almost every form of post-conviction? So a post-conviction petitioner comes in and says, I didn't know that my lawyer didn't interview my alibi witness. And I just now found out about that, but the statute of limitations is run. But my knowledge arose when my attorney told me 2 years later.
No, Judge, I would disagree.
Okay.
Because, like, say, if you have the example of a person who goes to trial, they watch their attorney do a bad job, and they say, gee, he did a horrible job. and they lose on appeal, and they're sitting in prison, they know from that moment that there's things wrong in their case. They know that they lost.
Well, then let me change Judge Ringhold's hypothetical then. Your client pleads guilty, and because his attorney says, there's nothing we can do. And you find out 7 years later, your attorney never interviewed your alibi witness. So you don't know, to contra the argument you just made, you didn't watch him perform. You didn't know he didn't interview the alibi witness. And now 7 years later, because, I guess your attorney has a change of heart, he sends you a letter and says, hey, by the way, I never interviewed your alibi witness. Why wouldn't that fact scenario apply here?
I think it's different because when you consider whether or not they interview an alibi witness, that goes to the proof in the case and not to collateral consequences. That's what the Padilla court was concerned with. You see, like, if I were to plead to a misdemeanor, it might make me deportable, but it might not have long-term effects as far as my guilt or innocence phase. But when you talk about the Padilla context, it goes to their right to remain where they've lived. It goes much further than the conviction itself.
So, and I want to clarify a point you made when you first started. You said your wish would be that we reverse it and send it back for a new sentencing hearing.
No, Judge, for an evidentiary hearing on the merits of the petition.
Because I thought I heard you say sentencing hearing. I was like, well, that's not going to help you, and he's still got a conviction. He's still deportable at that point. So, okay.
And to kind of review the record, the court pretty immediately said, no, this is outside the statute of limitations. We moved for rehearing. That rehearing was not granted. And we were not even granted an evidentiary hearing at the rehearing. And if you look at cases like the Whitehead case, the Whitehead court looked at it and said, we don't have a record because the court wouldn't let him into court. He didn't get a right to be heard. He didn't get a meaningful hearing. And I would assert that's what happened in this case. We didn't even get to be heard on tolling.
So at what point did the petitioner become aware that there was a Padilla issue? Was that in 2017?
Yes, Judge, and I'm glad you came to that because that's part of the diligence. He found out in 2017, and it's miscited in the record. That was prior counsel. I wasn't aware that this was an issue, but my client brought it up to me. It's Barry Frager was his immigration attorney who told him, hey, you're deportable. You need to fix this. And he immediately went to the Ballin firm, which I think the court is probably familiar with. The Ballin firms are great criminal defense attorneys, and the state has conceded, and we agree, that the Ballin's advice that this would be an effort in futility, that the case law is not in his favor.
But in 2017, he was aware that there was a claim. Lawyers are giving him what you may believe is inaccurate advice or bad advice, but he knows that he has a claim at that point. He can file a pro se motion or pro se petition for post-conviction relief. Why is it not until 5 years later? I mean, is it really just at the end of 5 years I received advice from counsel that I could proceed? Is that the entire argument?
No, Judge. What happened is in 2017, he consulted with a criminal defense lawyer. They told him that effort would be futile, which would, based on most of the later arising cases, is accurate. And then his immigration attorney told him that if you stay in the United States, you'll be deported and it will be impossible for you to return. He returned to Tunisia for 4 years until he could get a visa to come back. And under the Whitehead standard and the Supreme Court law it was under Downs versus McNeil, which I think is an 11th Circuit case, they said that due diligence, but it's cited by Whitehead, due diligence is not undertaking repeated efforts in futility, which I think is what his previous attorney would have advised him.
Let me stop you for a second. We talk about due diligence. And there's a period of time here I'm interested in. 2017, you said he consulted with an attorney to found out about his immigration status. Was that the same time that the violation of probation had been issued?
I think that was issued after he returned to Tunisia. He didn't actually get arrested until 2021.
But he went back to Tunisia in 2017.
Yes, Judge.
And he winds up coming back in 2021 or 2020, and he gets served with this warrant.
Yes, Judge.
All right. So, again, going back to Judge Greenhold's comment, he was already aware there was a problem.
Yes, Judge.
But he did nothing to address it until after he got arrested on his warrant for violation of probation.
I think, he actually addressed it after he was released on that warrant. It wasn't like he was in jail and called us and said, I can't get out of jail because of this warrant.
But the point is, there was rumblings several years beforehand that there was a problem, but he didn't address it until all this stuff happened.
You're right, Judge. He didn't address it until he was back in the country and out of incarceration.
How is that due diligence?
Judge, as the case has said, that it does not require efforts in futility. It requires reasonable steps.
But it seems like this looks more like steps to avoid than steps to address. That's what I'm trying to cycle myself through to see whether or not this sounds more like he was trying to avoid the problem than actually deal with the problem.
Judge, he obtained a visa to come back to the country to address the problem. That is a significant step to that.
What do you think a step in futility is in this case, though?
I think it would be filing without counsel.
Why is that a step in futility? It happens every day.
Because if we look at the other cases that cite this, he would have been unsuccessful. And he did go to counsel and try to hire counsel for that purpose. And counsel told him, you're not going to be successful.
But we're talking about the merits of the claim may be different from the procedural posture of the claim. And so merely because he would have been unsuccessful or may have been unsuccessful on the merits of the claim didn't somehow preclude him or act as circumstances outside of his control to preclude him from filing the petition in the first instance. And I think that's what the due process standard is focused on, is what measures outside of the petitioner's control prevented him from filing timely. That doesn't have anything to do with the merits of the claim.
Well, and there are other things that we haven't gotten into yet, which are the fact that he's not a United States citizen. English is not his first language. When we talk about the difference between a person who speaks English filing a petition pro se and the difference between a person who can't remain in the country, has been advised to leave the country, who has been advised that he has no claim, trying to undertake and file a petition in a language that's not his own.
I'll stop you right there. He hasn't been advised he can't file a claim. That's not a true statement. He may have been poorly advised, maybe not so poorly advised, but he may have been poorly advised that filing a claim would not give him the result he wanted. But to say he was told you can't file a claim is not, at least as I understand the briefs, that's not accurate factually. So again, kind of piggybacking what Judge Greenholz's talking about, whether he could win is not the due process issue. Whether he can procedurally file is the due process issue. And he was never, one, he was told he had a claim, potential for a claim. And two, he was never told he couldn't file one. As a matter of fact, he was told he could, it just may not work. So that's what the due process is, just trying to get you the opportunity to get into court, to be heard on the merits.
Yes, Judge. And
it doesn't seem to me in reading all this, or I'm confused, where has he been precluded from getting into court once he found out about it?
so I would argue that under the case law, 2017 would have been too late. The difference functionally between 2017 and 2022 is that he was precluded from that knowledge, and if he had filed, he would be in the same posture.
Let's stop you there, right there. Doesn't it make a difference if you file as soon as you find out about it as opposed to waiting 3 years?
Reasonable diligence.
I think the problem is when you try to hire a law firm to file it, they won't file it, and you don't speak the language. That's the extraordinary circumstance.
Haven't we already held, though, that a petitioner's inability to read, write, or speak English does not give rise to due process tolling? That's the Vasquez case. So we keep coming back to the language barrier, but this court has already rejected that as a basis for due process tolling. How do you distinguish Vasquez?
I think because when we talk about due process in the context of Whitehead, which both parties have agreed is the standard, if we consider that, then we look at the diligence, which I think is what the court is has an issue with, is he didn't file in 2017. But then the extraordinary circumstance is still an individualized assessment. What was he going through? He was facing immediate deportation and had to leave the country to avoid not being able to return and assert his claim. Asserting his claim would require him either beating the deportation proceedings or doing what he did, which was to leave, apply to be here legally so that he wouldn't be held up by that, and then face his violation of probation, which he did, and then find counsel who will assert the claim.
What precluded him from filing a pro se motion and then leaving voluntarily while his pro se motion is pending? And I mean, what precludes him from doing that?
I think
he didn't have to beat the deportation proceeding in order to file his claim.
That's true, but he does have to have a working knowledge of English in the court system.
Well,
and
Vasquez,
or
if I can come back to this respectfully, Vasquez actually says this: we reject the argument that due process requires the post-conviction statute of limitations may not be applied to petitioners who cannot read, write, or speak the English language.
And I think that cuts completely against what Padilla was trying to do, which was to protect these people. I think there's a significant policy concern if we say that attorneys can give bad advice, not tell their clients what's going to happen to them, that they're going to lose their home and their family, and then as long as they don't speak up for over a year, then it's gone. The Padilla court spoke quite eloquently about how the difference between commission and omission is irrelevant in this case because they are a protected class.
But Padilla didn't go as far as you want us to go, and that is, once he finds out about it, depending on his or her ability to speak, read the English language, he then has an infinite period of time in order to figure out how to get into court. Padilla still says once you kind of figure it out, you got to get in court.
And I think that's what he tried to do when he went to one of the best law firms in Tennessee and they told him, we're not going to court for you.
But once again, that didn't prevent him from filing the petition, right? I mean, I think what you want us to hold is that the time for filing the petition doesn't run until you find counsel that agrees that your claim has merit. I think that's really it, right?
I think only in this context when you have a person, and again, it's an individualized assessment, who doesn't speak English and who is being told by his attorneys, leave the country and come back and file. And he does that. Again, I know the case law about misadvice, but we're looking at, and especially when you look at the record and what was actually done to him, is that he had an attorney who pled him guilty above the minimum to probation as charged and didn't advise him of the immigration consequences. If you look at Whitehead, that's abandonment. It's complete abandonment, and it also deprived him of the knowledge of how to address that abandonment.
You're into your rebuttal times.
If there's no more questions, then we would ask the court to reverse for an evidentiary hearing on the merits. Thank you.
Your Honors, Jonathan Wardle, I hope you're not tired of hearing from me.
I had a couple more questions about bonding agents.
It's the state's position that the trial court properly summarily denied this petition based on the expiration of the statute of limitations. If you want to take advantage of the due process tolling, you've got to allege facts that would support your claim, and here he didn't, for the reasons that you all have asked. The biggest issue, and the one that the court seems to have hung its hat on in its order, is he didn't do anything after 2017. The discovery rule doesn't apply, so really the fact that he found out about it in 2017 shouldn't toll the statute. But even if we wanted to give him that grace and say, okay, 2017, he doesn't do anything for almost 5 years. He talked to one attorney, not multiple, didn't file a pro se petition, didn't do anything, ran away from the country. Whether or not that was on attorney's advice is not actually alleged in the petition. I don't know where to go other than he didn't pursue his rights diligently, and that's required. I could address other questions, but I think that's the crux of the matter, unless y'all have further questions. Thank you, Your Honors.
Thank you. You have your rebuttal time, 4 minutes.
I don't necessarily think that there is much to rebut other than that we have our positions. However, the record doesn't indicate specifically that he was advised to leave the country. It indicates that once he was out of the country, he did seek that visa. That is in the petition. And again, part of the issue is, like in Whitehead, we did not get an evidentiary hearing to put on the full breadth of our proof as far as due process tolling. But he did take what I think the Whitehead court would have called a reasonable step. He got a visa to come back to address those claims. And then he didn't consult with just one attorney. He consulted with 3, his immigration attorney, the Ballins, and then eventually us. Finding an attorney to do what we'd call in our brief a Sisyphean task, to push the boulder up the hill on a claim that has very little support as far as case law goes, but is in the spirit of Padilla, I think, is difficult, and he did find that. So with that, we would ask you to remand for an evidentiary hearing on the merits.
Thank you, Counsel.
Thank you. Thank you.
Do we have any other matters? Thank you. With that, we will adjourn this session of the Court of Criminal Appeals.
All right.